Is Mikhail in court yet? You people are not talking.
I think he's online. Maybe he's having issues with his audio. I can see him on the screen.
Okay. Let me try and send a message. Oh, yeah. Okay, let me first check the status. You see him on the screen? Yes, let me try.
Yes, my lord. Is he on the screen?
So, okay, yes, I can see him. His video and audio are all off. His video and audio are all off. Let me send a message. Oh, wow. That's good. I just sent him a message on the chat. I hope he sees it.
Be allowed to contribute, Lord. I will prepare that this case is stood down on the message. God.
I've not yet taken, okay, yes. Okay, we will stand down the matter if it.
Record, please.
Okay. It's a win problem with this audio. Then he should speak out. Mikhail.
Mikhail, speak out. Hello?
Okay, we'll call another matter.
Record, please.
Thank you. I don't know.
I think that are not.
ILO 2026, National Union of Butchery Workers of Nigeria and Incorporated Trustees of Irekodun United Butchers Association of Nigeria. Appearances?
My Lord, I'm A.W. Yahaya, My humble appearance is for the claimant.
Yes, defense counsel.
May it please this honorable court. My name is Ibrahim Alabidun. Ibrahim Alabidun.
H-E-E-M. Ibrahim
Yes,
as in
Alabidun.
H-E-E-M.
Alabidun, sir.
Ibrahim as in H-E-E-M.
Yes, sir.
Okay.
H-I-M, sir. H-I-M.
Alabukun.
Alabidun. Alabidun, sir.
Okay.
I appear for the first defendant, sir.
All right. Who appears for the second to seventh defendants? Any counsel for second to seventh defendants?
Yes, my lord.
They
May
announce
please,
your
my lord.
appearance. Yes.
My lord. I am Rahim. May please, my lord. Please, my lord.
You are
I am
who?
Rahim.
Just Rahim.
I am Ismail Rahim. I appear with ML. Please, my lord. Ismail Rahim. I appear with ML. I appear with ML Ablaoniye. For the fifth defendant, sir.
You are with who? You appear with
M as in mat, L as in leg. M as in mat, L as in leg.
yes.
The Abdullahi Oniye is a compound word, sir. Abdullahi Oniye is a compound word, sir. Abdullahi Alfi Oniye. For the fifth defendant, sir. For the fifth defendant, sir.
May it please, my noble lord.
Yes.
I'm HK Onimago.
Yes.
I'm an assistant chief state counsel.
Yes.
I humbly announce my appearance for the second
Assistant Chief Counsel, you belong to a particular Ministry of
Chief State
Justice.
Counsel of Ministry of Kwara State Ministry of Justice, my lord.
Thank you.
I humbly announce my appearance for the second, third, fourth, sixth, and seventh defendant respondents, my lord.
Second, third,
fourth,
and
sixth, and seventh defendants, my lord.
I think that is all for the appearances. I think we are all covered.
I'm sorry for my late appearance, my lord.
Okay.
Thank you, my lord.
No claim. Okay. Yes. Yeah. Yeah, yeah. Yeah.
Yes, my lord.
Yes.
My lord, the matter is for hearing this morning.
Okay.
The matter is for hearing this morning.
Yes.
However, my lord,
General form of originating summons. Yeah. You
Yeah,
filed
my
a
lord.
general form of originating summons. Congratulations. You didn't read our rules.
I did,
Is
my
there
lord.
anything like general form of originating summons in the rules? We only have general form of complaint. The other one is originating summons, not general form of originating
Thank you, my lord.
summons.
Thank you, my lord. I'm well guided, my lord.
Thank you very much. The matter today is for hearing. However, yeah.
My lord, sir.
You said the matter is for hearing today. However, continue now.
However, my lord, we have an application before the court. However, my lord, we have an application before the court.
Introduce the application.
The application is dated and filed 10th
The
of February
application has
2026.
a name, sir. The application should have
Thank you,
a
my lord.
name.
For an order.
Yes. The
Application for
application
an
should
order.
have a name. What is the name of the application?
The application is to discontinue and withdraw this suit.
The name of the application is a motion on notice.
Motion on notice, my lord. We have a motion on notice, which is dated and filed the 10th of February 2026.
Seeking
for an order of this honorable court to discontinue
yes,
and withdraw this suit against the second, third, fourth, fifth, sixth, and seventh defendant.
all the defendants except first defendant.
Except the first. Grateful, my lord, sir.
please.
So why are you?
And two, my lord.
I think the most proper. Anyway, discontinue is still all right, but maybe you should have used striking out their names, as simple as that.
As God pleases.
And to amend
the
originating summons accordingly.
Accordingly, my lord.
Have you filed the amended process?
We attach the amended process, my lord.
Okay, so you are asking for a deeming order? You
No,
didn't
sir, we are
pray
not
for
asking
a
for a deeming order, sir.
Why?
We have filed a proposed amended copy, my lord, as an exhibit.
No, fine. Just attach.
I asked you, I said, have you filed the amended process? You said yes.
So why are you not asking? Proposed amended copy, my lord.
You filed only the proposed amended copy. You did not file fresh copy. Why didn't you file fresh copy?
Pardon, my lord.
Why did you fail to file a fresh copy?
Well, we believe that we have to get an order of your lordship, sir, before we can file an amended copy, sir. That's why we attach a proposed amended copy as an ABC.
The defendant counsels, have all of us been served with the motion?
All parties have been served, my lord.
You are not the defendant counsel, are you?
As court pleases.
As court pleases. We have been served, my lord.
On our part, we have been served with the motion, sir.
Okay, is anybody objecting to the motion?
My lord, on behalf of the second...
No, just we are objecting, that's all, because we are still... It's just to determine how he will move his motion. We are objecting, we are not objecting, that's all. I'm still going to call for your response on record.
We are not objecting, my lord.
Okay.
On our part, we are not objecting.
Okay, so we move in terms.
The taking of the application.
Thank you, my lord.
We move in terms.
My lord, sir, I humbly move in terms of the motion paper and all your lordship to grant same accordingly.
My lord. My lord.
Yes.
On behalf of the fifth defendant, sir.
No.
We have been served with the motion and we have no objection to it, sir.
The counsel for first defendants should respond first. That is Ibrahim Alabi.
Yes, sir. We didn't.
Alabidun.
Lord, we didn't find. Yes, sir. We didn't find any response to the application.
Are you objecting? No objection.
No objection. Well, you shall be asking for. Sir.
You shall be asking for cost.
As court, please.
You are counsel to the first defendants.
Yes, sir.
No objection, but we shall be asking for cost.
As court pleases.
All right. Okay. Onimagu. HK Onimagu.
My lord, I'm with you, my lord.
You are next because you appear for the second and third and fourth defendants. So you should come up next. Yes.
On behalf of the second, third, fourth, sixth, and second defendant respondents, my lord.
Yes.
We are not opposed to the application to discontinue the suit against us, my lord.
No objection.
However, my lord.
Yes.
We have joint issues with the applicants, my lord. We have filed a counter.
Yes.
We urge, my lord, to make an order of dismissal of the suit against us, my lord, and not striking out. My lord, we are fortified by the authority, the Supreme Court decision, my lord.
Let's start with my rules.
As court pleases.
Order what will what?
51.
Yes.
My lord, just a minute.
You just have Supreme Court authority and you just come. If my rules doesn't say so, will the Supreme Court impose an authority for what my rules should do?
My lord, I leave it to the discretion of my lord.
No.
We are bound by...
You are simply telling me you don't know my rules. And somebody was already metering it out for you. You must know my rules. You are appearing before me. You must know my rules. Because that is the foundation upon which any decision is made up to the Supreme Court. Because these are merely like more of administrative matters.
As God pleases, my lord.
Okay, let's have your Supreme Court matter.
My lord, that's the case of Ekudano versus Keregbe.
Ekudano.
Yes, my
versus
Ekudano and other and
yes.
another versus
yes.
Keregbe and others.
Yes.
2008.
Yes.
LPELR.
Yes. We're waiting for you, sir. LPELR what? By me laptop now.
My lord.
Yes. Citation, sir.
1100 SC, Supreme Court, my lord.
$1100.
Yes, my lord.
SC.
Yes, my lord.
2008.
Yes, my lord.
Okay. It says, what does the authority say?
That it must be noted that in deciding whether to strike out a suit or dismiss same upon an application by the plaintiff to withdraw same, particularly at the stage where evidence has been laid in the matter, the court's the court concerned is being called upon to exercise its discretion one way or the other based on the fact and circumstance of the case.
That talks about where evidence have been laid in the matter. That's the particular authority cited. Has evidence been laid in this matter?
My lord, just a moment, my lord.
Okay.
My lord, there is in the same case, my lord, it was held that the law is settled, that the principle underlying the requirement for leave to discontinue a suit is that after proceedings have reached a certain stage, the plaintiff who had brought his adversary into the court should not be allowed to escape by the side door and avoid the contest. At that stage, he is no longer dominus litis, and it is for the learned trial judge to say whether the action should be discontinued and upon what terms. It follows, therefore, that a plaintiff may, without the leave of court, discontinue a suit against all or any of the defendants, or withdraw any part of his claim before the date fixed for hearing. In such a situation, the notice of withdrawal automatically terminates the proceedings, and a formal order striking out the suit may be made by the court. See Sueton versus Total Nigeria Limited. It goes further to say that, but where the request for discontinuance is made after the date fixed for the hearing of the suit, the plaintiff may discontinue only with the leave of court and subject to conditions that may be imposed by the court. In granting this request, the learned trial judge may order that the case be struck out or make an order for outright dismissal of the suit. Whichever order the court makes will depend on all the circumstances of the case, and an appellate court will not ordinarily tamper with the trial court's exercise of such judicial discretion.
Yes. So in this case, what is the circumstance? upon which you want the court to dismiss the case.
My lord, in this case, my lord, the case has been fixed for hearing.
Yes.
And we have joint issues. We filed our counter. They've seen our defense. Now they want to escape through the side door. We don't want a situation whereby they will withdraw the suit now and come back again to file a fresh suit. So, my lord, I urge my lord, by this Supreme Court decision to dismiss this case against the defendant, my lord, against us.
Okay, thank you.
Yes,
there is another counsel. There is another counsel.
Yes, my lord, the fifth defendant counsel.
Abdullah.
Yes, my lord.
Oniye.
Yes, my lord.
Abdullah.
We have no objection to the withdrawal, sir. We have no objection.
Okay.
I have, sir. We align with the submission of the council to the second, third, fourth, sixth, or seventh defendants.
You said, however, what?
However, we align with the submission of the council to the second, third, fourth, sixth, or seventh defendants, sir. We urge my lord to dismiss this case because
your friend
has joint issued with the applicant.
Yes. You said you relied on his submissions and you want to repeat it. You relied on his submissions, which means everything he said. You have joined issues already. Yes.
So for the first to be awarded against the claimant, sir. In favor of the fifth defendant. Because expenses were incurred in filing processes.
Your learned colleague relied on the Supreme Court authority. He did not cite the relevant provision of the rules of this court, and I thought you would do so. You too, you are not aware of where it is found in the rules of this court.
My lord, I am aware, sir.
Yes, so cite the rules for the what rule what authorizes this your submission.
My lord, sir, it is order 61 rule 7 of your lordship rules, sir. Order 61 rule 7 of your lordship rules, sir.
Read it.
My lord, where a claimant withdraws or discontinues a claim or suit or any part of the claim after a defendant has joined issues by filing a defense within the time prescribed by these rules, such suit shall be dismissed by the court.
Good. You see, that one is more straightforward, isn't it? Thank you. Yeah.
Yes, my lord.
They are saying I should use Order 61, Rule 7, and the Supreme Court case cited of Ekundano versus Kurebe to dismiss the suit against them and not merely striking out.
Well, my lord is bound by the rules of the court, my lord.
Yes.
There is no doubt about that.
So, what do you say?
Well, that's what I'm saying, that my lord is bound by that rules, my lord. That is Order 61, Rule 7.
So you don't object to their own application to dismiss the suit against them?
We can't go against what the rules of my lord says, my lord. Except, sir, on the issue of cost asked for by the first defendant.
The first defendant
say he's not opposing, but he's asking for cost.
Yes.
On the issue of cost being asked for by the first defendant, I humbly pray, my lord, sir, to make it a cost in cost.
Okay.
While on the cost being asked for by the fifth defendant, my lord.
Yes.
I humbly pray, my lord, sir.
Yes.
I humbly pray, my lord, sir.
Yes.
To other party to bear her cost, my lord, sir. More so, my lord.
Yes.
The reason for the withdrawal and its continuance is amply stated in our affidavit in support of the application, my lord.
Which is
the intervention of the head of service.
Is what? State. Is what?
The reason for the withdrawal, my lord, sir.
Yes.
Is amply stated in our affidavit in support of the motion,
you
my lord.
Said which is something,
which
and
is the intervention of the head of service of Kwara State.
Okay.
The intervention of the head of service of Kwara State.
Okay. Paragraph.
That is paragraph 4, my lord.
Okay.
Paragraph 4, 5, and 6.
Okay. All right.
Thank you, my lord.
My lord, sir.
Yes.
Your lordship cannot make the order as to cost to be cost in cost, sir. Because The amendment sought to be
Cannot.
Your Lordship cannot, with respect, sir,
Cannot.
make the cost as cost in
I
cost.
cannot.
Yes, sir.
I cannot. Okay.
Because the amendment sought to be done will necessitate us to file another process entirely to reflect the new parties on record, sir.
And so because of that, the court cannot
Yes, sir,
order costs in
yes, we
costs.
have expended money to file counter against this suit,
All right.
and it's making us to expend other money.
Your authority, sir, the authority that says I cannot order cost in costs because you have filed processes.
Yes, it is discretionary, sir, and I'm urging your Lordship.
I thought you said I cannot, and you are saying it's discretionary.
Yeah,
What is
I'm sorry.
discretion?
I'm sorry. I'm sorry in that regard, sir. It is discretionary, and
That's why I kept emphasizing cannot.
yes,
Because you
sir.
are saying cannot, I kept emphasizing cannot, and you kept saying yes.
As call, please, sir. I'm very sorry in that
If you
regard,
are
sir.
urging me not to make the order, I urge the court not to make it cause in course. But you are saying court cannot. Then you have to give me authority. The thing that bound my hands. The
As
thing
call,
that
please,
bound
I
my
urge your
hands.
Lordship to not make it as cost in cost.
Okay, thank you.
As call, please, sir.
Àwọn your share. Your share. Back at the physical diary, Abashola. How will you? Yo, man, it's March.
Yes, ma'am.
This is the ruling of the court.
As court pleases.
As court pleases.
I find on record that all the defendants have joined issues with the claimant before the application to discontinue the case against them. By Order 61, Rule 7 of the rules of this court, the appropriate order is one of dismissal, stated in the mandatory language of shall. The suit against the second to 7 defendants is accordingly dismissed.
As court pleases.
Counsel to the first and fifth defendants stated to the defendants said they shall be asking for cost. That is a statement of intention to ask for cost. Little wonder, none of them stated any amount of cost being asked for. I make no order as to cost.
As
The prayer to amend the statement of the prayer to amend the complaint and statement of facts is granted, and a fresh copy is to be filed within 7 days from today. Case adjourned to 11th May 2026 for hearing.
As copies, we are most grateful, my lord.
Thank you very much. If you are used to my code, you know I always have problem with this. We shall be asking for cost, full stop. I always treat it as a statement of intention. And I take it to mean you haven't asked for cost, but you shall be asking. So you will ask for it when the time arises. Yes.
As copies.
As copies.
Back to AK 2025 between Olabisi Abiodun Babalola and the governor of Osun State. We were waiting for the appearance of claimant counsel.
As the complices, my lord.
Yes.
Good morning, my lord. I am IA Mikhail. Appearing with me for the claimant. Mikhail is spelled MIKAHEEL.
Yes.
And appearing with me.
Yes.
For the claimant are DA Okunlola. Okunlola.
Yes.
And AD Adeyemi. Again for me, Lord.
Thank you. Olakunle Lawal, you are still online?
Yes, my lord. I'm still online.
Okay. You are for the defendants.
For the defendants, my lord. I'm most
Mikhail.
Yes, my lord.
Yes.
We have the matter is listed for hearing.
Yes.
But we have a house clearing application, my lord.
We have a motion on notice
A
dated.
motion on notice. It's dated 17th March 2026, my lord, and filed the same day.
It seeks for
Regularization and another for extension of time to file the claimant's applicant to file further affidavits and a reply to the counter affidavit and address of the defendant's counsel.
Which one is reply?
Well, we have a reply in point of law, my lord.
Okay. That reply on point of law is the written address that should follow the further affidavit, isn't it?
Yes, my lord. Yes, my lord.
Okay. Although you can actually decide to file only a reply on point of law without a further affidavit. Okay. Yes, Olakunle.
Yes, my lord. I have no objection to the application, my lord.
Okay. We move in terms.
As a couple places. My lord, we are hereby move in terms of the motion paper and hold my lord to grant the application as such. Grateful, my lord.
Application granted as prayed.
I record, please.
Yes. Mikhail, what next? Mikhail. Mikhail.
Yes, my lord.
What next?
My lord, the next is for us to go to the hearing of the originating summons, the substantive
You
matter.
are ready for hearing.
We are ready for hearing, my lord.
Olakunle.
I'm ready, my lord.
We are ready.
We are ready, my lord.
Yes.
I'm more grateful, my lord.
Your clients are part of the proceedings. So
I'm
it's
more,
you
I'm
and
more
your
grateful, my
clients.
lord.
That's part of the reason for us always saying we are ready, because you are acting on behalf of someone.
I record,
So
please. I'm
you
more
and
grateful, my
him
lord.
is we, not I.
I record, please. I'm more grateful, my lord.
Thank you very much.
Yes,
Yes,
Mikhail. Yes,
the
my
ball
lord, but
is
before
in
I
your
go
court.
to the originating summons,
Yes.
in calling the matter, Abiodun was called instead of Abidemi, my lord.
Say what?
Olabisi Abiodun Babalola was the name pronounced instead of Olabisi Abidemi Babalola.
It's Abiodun that I have on my file. Sorry, sir. Olabisi Abiodun Babalola. That's what is on my file. But let me look at on your process.
The process is
Olabisi Abidemi Babalola. Can you see? I don't know where you people find Abiodun. It's Abidemi. So take note so that you people correct it. Thank you very much. In writing my judgment, I'm not going to go by the name on the file. I'll go by the name on the process. Thank you very much. All right.
And again, when the matter was earlier called, the claimant was in attendance. But I wouldn't know, maybe his network or so.
He didn't say anything.
As a complainant. So,
Claimant Claimant online, right?
Yes,
so
Lord.
let's see the claimant. Claimant, let's see, you just say.
Mr. Obalola, are you still there? I'm not sure he's still online.
Why? Why won't he be? Actually not online.
The matter was initially called first time before it was children.
When the matter was first called, right?
Yes, my lord. Yes.
Okay, let's proceed to the hearing.
As a complainant. My lord, our originating summons was filed on the 5th day of November, 2025. Commenced by way of originating summons, filed on the 5th November, 2025.
It seeks for determination of how many questions?
We seek for determination of 3 major questions, my lord.
And how many minor questions?
Though the minor ones are not stated, but they are embedded in the wide part of the honorable court.
It's 3 questions. You said 3 major questions. So that means there are other minor questions. All right. And the grant of how many reliefs?
We have 8 reliefs, my lord. We are seeking 8 reliefs.
Okay.
Declaratory reliefs and consequential reliefs portion to the.
Okay.
Okay, Mr. Awala is back online, my lord.
Okay. Because this is public hearing, at least let us hear the questions.
As a complainant. My lord, the questions we submitted for determination of this honorable court are whether, upon a proper construction of the provisions of Rule 02, 07, 01, A, paragraph AB, D and D3, under section 7 of chapter 2 of Osun State Public Service Rules, and the claimant's terms of employment as contained in his letter of appointment dated 21st May 2004, and the claimant not being under any disciplinary action, the defendant can deprive the claimant his hand promotion from Deputy Director, grade level 16, to the position of Deputy Director, grade level 17.
Okay. Okay, all the other 2 questions are related to this issue, isn't it?
Hello?
I said the remaining 2 questions are also related to this issue of
they are
promotion.
also related to the issue.
Yes, so no need to read them further. We know the main contention is the promotion of the claimant from grade level 16 to 17. That's the issue before the court, isn't it?
Yes, well, that's the issue before the court, but it's not actually the promotion that we are contesting.
Okay.
We are contesting the denial of the claimant
then read question
opportunity of being interviewed.
Read question 2 and 3, Council.
2 and 3, my lord, that
Yes.
whether upon a proper construction of the provision of rules 100101, 100201, paragraph M, and 100231, under section 1 and 2 of the Osun State Public Service Rules, and the content. Am I still there, beloved?
You are the one that have gone mute.
Okay, my lord. So, the entire provision of Osun State Public Service Rules and the content of the claimant's letter of approval of leave of absence with reference number SMD 254 volume 220 dated 5th March 2025. The defendants are empowered or authorized to deprive the claimant hand promotion from position of deputy director grade level 16 to position of director based on the ground that he was on leave.
Okay.
And I tell you, my lord, whether having regards to the provisions of rule 020701, paragraph A, B, and D3 under section 7 of chapter 2 of the Osun State Public Service Rules and the claimant's terms of employment as contained in his letter of appointment dated 21st May 2004. Rules 100101, 100201, paragraph M, and 100231 under section 1 and 2 of the Osun State Public Service Rules, the entire provisions of the Osun State Public Service Rules, international labor practices and standards, and the content of the claimant's letter of approval of leave of absence, with reference number SMD 254, volume 7, 220, dated 5th March 2025, the decision of the defendant to deprive the claimant his hand promotion on the ground that is on leave of absence is arbitrary, discriminatory, and amount to abuse of administrative powers when none of these rules, the rules guiding his employment, prescribe such deprivation. So these are the 3 questions.
Thank you very much. Let's proceed.
So we pick 8 reliefs, as I've mentioned earlier, my lord.
Yes.
And in support of the originating summons, we filed an affidavit of 35 paragraphs, deposed to by the claimant himself.
Yes.
The Lord, attached to the annexed to the affidavit are 7 exhibits. Marked as exhibit
7 annexures marked as exhibits.
Exhibit A.
Yes.
To exhibit A to G, my lord.
Okay.
So, my lord, we qualified a written address in support of the originating summons.
Yes.
We seek to and we hereby adopt the said written address as our argument, my lord.
Okay.
So, my lord, upon
You also filed a further affidavit.
Yes, upon the receipt of the reaction of the defendant, we qualified a further affidavit.
On?
It's of 9 paragraphs, my lord. We filed it on the 17th March 2026.
And deemed today.
And deemed today.
It is of how many paragraphs?
It is of 9 paragraphs, deposed to by the claimant himself, my lord.
And a written address.
My lord, in support of the attached to the further affidavit is also an annexure, though erroneously tagged Exhibit G again. So we have 2 Gs, my lord. A G with the main affidavit and a G with the further affidavit.
Okay.
So in support again, we filed a reply on point of law.
Yes.
We seek to adopt, and we hereby adopt our said reply, which was also due, properly filed and served this morning.
And urge the court to grant our release.
And urge the court to grant our release as claimed.
Yes. What is
so, maybe I should adumbrate, or I should wait for the defendant counsel to make a submission to adopt its processes.
Before you adumbrate? You should adumbrate. In fact, I was already asking you, what is the crux of the affidavit?
The crux of the affidavit that we filed.
Yes.
Is that, I mean the initial affidavit or the further?
The initial affidavit, is the case going to be done on the further affidavit or on the initial affidavit? The further affidavit is just
the main
to answer
something
that arises from the counter affidavit, isn't it?
Yes, my lord.
Good. So
yes,
I'm talking about the main affidavit. What's the crux?
Yes, my lord, the main affidavit and the crux of the main affidavit is that the claimant, being a civil servant in the attached to the Ministry of Justice in Osun State, and being on the grade level 16.
Yes.
He has been on a leave of absence for some time.
Yeah.
But during his leave of absence, my lord, it has always been that whenever there's a promotion exercise, he has always been invited for interview, attended interview, and promoted along his peers in service.
Yeah.
At least we have attached his promotion, the promotions hand in such
what
circumstances.
Happened this time around?
What now happened this time around, my lord? When he now got there, he was listed in Exhibit G attached to our further affidavit. His name is number 2 on Exhibit G of the list of eligible officers in service who are invited for the promotion interview. When he now got to the
Exhibit G of which affidavit?
Further affidavit, my lord.
Okay, good. I need to
Exhibit G of the further affidavit. His name is number 2 on the list. And that is the list prepared for the interview.
Wait first, counsel. We are going together. Yes, let's go together. Let my eyes fall on it. This table, right?
Yes, my lord.
Okay.
His name is number 2, Mr. Olabisi Abidemi Babalola. M as in sex, date of birth given, post of first appointment stated, date of first appointment stated, date of confirmation stated.
I've seen it.
As the corporate says, having listed him and having invited him to attend the interview. Of course, the first person was called, interviewed, and left. When it got to his turn and it got to the desk, one of the officers, of course, who is not a lawyer, the permanent secretary of Ministry of Justice and Solicitor General was also part of the panel that they are supposed to interview him. So when it got to his turn, one of the officers, one of the panelists, just raised an issue that, oh, but you are on leave of absence without pay. He answered yes. He now said there is a recent policy by the government, that it is not possible for anybody on leave of absence to get promotion. So, and this is the crux of the matter. He was denied the opportunity of being interviewed. He made all the entreaties to ensure that he was listened to, even if they interview him and it now turned out, oh, that he did not pass or he did not do that, but they did not even interview him at all, my lord. And that's our grudge, that you have listed somebody as being qualified and competent to be promoted to grade level 17 from level 10. He has enjoyed such privilege or such rights in the past. Like 3 or 4 promotions come when he was on leave of absence without pay. And he has always been promoted along his peers. So we didn't know what actually happened. We didn't know what, even the Solicitor General was surprised. She was taken aback. That why would somebody say this? That where is that? In fact, it was the person who said it was challenged. But till date, the defendant have not been able to provide anything, either in the rules, in the public service rules, or in the letter of appointment, or in this approval for leave of absence. The only condition attached to it is without pay. So if it were to be listed that he will not enjoy any promotion whatsoever, or he will not be allowed to attend interview or screening for promotion exercise, of course he would have weighed his option before going on such a leave without pay. And my lord, our contention is that a civil servant who is on leave, either leave of absence or leave of absence without pay, or any form of leave, remains a civil servant, and he enjoys all the privileges enjoyable by civil servants, particularly of his peers. And this is the crux of the matter, my lord, that
thank you.
The defendant have acted in an arbitrary manner by not allowing him to attend interview. And we wrote to them, which they received and they did not respond to me, lord.
Thank you very much. Yes, Olakunle Lawa.
Yes, my lord. Yes, my lord. I'm most obliged, my lord.
Yes.
My lord, in opposition to the claimant originating summons, the defendant filed a 31-paragraph counter affidavit in opposition to the claimant originating summons, my lord. The defendant filed a 31-paragraph counter affidavit. The post-suit.
On what date?
On 10th February 2026, but deemed properly filed. It was filed on 10th February 2026, but deemed properly filed on 3rd March 2026, my lord.
Come and look at the process. Okay, I can see. I can see the motion before. Okay. Kana fita ka je ina ne? Ko ina ne ko yaushe kai dai kafan ka da kaci. All right.
Yes, my lord. The third counter affidavit was supposed to by Mr. John Oyetade Amoson.
Okay.
John Oyetade Amoson.
Okay.
a civil servant with the Osun State government.
Yes.
My lord, attached to the affidavit are 8 exhibits. 8 exhibits marked Exhibit A to H. Marked Exhibit A to H, my lord.
And a written address.
Yes, we also filed the written address dated the
Yeah.
29th day of January 2026. It dated the 29th day of January 2026 and filed on the same 10th February 2026.
Yes.
We most humbly adopt and rely on the said counter affidavit.
Yes.
As well as the written address.
Yes.
In urging your lordship, most humbly and respectfully, to dismiss the case of the claimant.
Okay.
Lord, if I may just in few minutes set the
Yes.
case of the defendant, my lord.
Sure, sure. I was even going to ask you.
At the court, please. I'm most grateful, my lord.
Yeah.
My lord,
Yeah.
this is a case, as your lordship will see from the exhibit attached to the counter affidavit, particularly Exhibit A to D to E, my lord. Exhibit A to F. Your lordship will find that cumulatively in the last 8 years, the defendant has only worked in the Osun State Ministry for 8 months in the last 8 years.
Okay.
8 months in the last 8 years. From Exhibit A, your lordship,
Only 8 months.
only 8 months in the last 8 years. My lord, Exhibit A, before your lordship, is an application letter by the same claimant asking for leave of absence for 4 years.
What is marked as Exhibit A here is the public service rules.
Oh, I'm so sorry, my lord. Exhibit B, my
Which
lord.
I was
I'm so sorry.
expecting the claimant to front load, and I looked at his documents. He did not front load the public service rules upon which his whole case resolved. I don't know.
My lord, I even raised an objection on that issue. There's an objection I'm written address on that issue.
Okay.
Which your lordship will find in the written address. We raise an objection to that aspect, my lord.
How can you are relying on the public service rules of Osun State? You've come to file the matter in NIC Akure, and it did not appear to you that you should oblige the court with a copy of the Osun State public service rules.
That is our argument.
My lord,
No, don't worry. Yep. You may respond after.
As a
yes. Yes, continue your submission.
If my lord look at Exhibit B, my lord, that is an application letter by the claimant asking for leave of absence for 4 years for him to go and serve as an advisor to a senator in the National Assembly.
Yes.
To go and serve as a senior legislative aide to a senator in the National Assembly for 4 years. After the expiration of the 4 years, my lord, the same claimant, before the 4 years even expired, the same claimant applied for another 1 year leave of absence to continue his duty in the National Assembly, making a total of 5 years.
Yes.
He came back from that leave. He worked for few months. He took another leave of absence again. Your lordship will see from the Exhibit B to F, he has only worked for 8 months while his colleagues have been working for the state government, and you expect to still get promotion with them, together with them, my lord.
So that is the reason why the defendant say, no, you have been enjoying on the other side. You cannot be enjoying double.
You cannot come, you can't, my lord, apart from that, my lord, promotion, it's a privilege. It's a privilege. It is not that because you have spent a certain number of years, you are entitled to promotion. There are so many authorities to that effect, my lord. So many authorities.
The issue here is he said you invited him for he was qualified, you invited him.
My lord, we'll get there, my lord. I'll get there, my lord.
Wait now. And then he was denied on the ground that he is on leave of absence. And he said, there is no rules that allows for that. And that you people say, that's the defendant said,
yes.
There was a circular or something to that effect, which you have not produced, according to him.
My lord, there is no circular whatsoever, and it is never a new policy, my lord.
The policy.
It is not a new policy, which we have countered in our counter affidavit, my lord. And we stated, going by the public service rule, we stated in extenso what are those requirements.
So, in brief, what is your justification for denying him promotion after listing him for interview for the said promotion?
No, my lord. The justification is that he had not met the requirement, my lord, and the requirements are there. Which, practically, my lord, if you look at paragraph 9 of our counter affidavit.
Okay.
Paragraph 9 of counter affidavit. We listed out.
Maybe paragraph 9.
Yes, my lord.
Of the counter affidavit. Also know that provided for by the Ocean State Postal, an officer can be eligible for promotion to the next grade, include but are not limited to. So, is order what rules? What of the public service rules?
My lord, all those ones are stated in the written address. Just a minute, my lord. They are all in the written address. We stated the rules in the written address.
Yes, lead me.
Everything is there. We even copied out the rules and put there in the written address, which your
lordship will see. To where it is in the written address.
Sorry, my lord. Okay, let me just identify the paragraph, my lord.
And let me commend you people for paginating your work. Because that is one fight I have been having with the lawyers here since 2019. They will bring processes unpaginated. Meanwhile, they have brought exhibits from non-lawyers which are paginated. Then it is the lawyer's work that would not be paginated. But I think you people have taken your time to paginate your work. I must commend you for that. Or maybe the claimant did not care to paginate his own work. Yes, claimant did not care to paginate his own work, but the defendant cared to do so. Please, a lawyer's work must always be paginated once it is more than one page. That is the rule of drafting. If we didn't do drafting in the university, I'm sure we did it in law school. Once a work is more than one page, you must paginate it. Thank you.
Yes, my lord. Starting from paragraph 4.26. 4.26 on page 14 of the written address.
Okay.
4.26, 4.7, 4.28 of the written address.
Okay. Okay, I see that. Pages 14 to 16. Or maybe it's up to 17, 18, and 19. All right.
Yes, my lord. Up to 20, my lord.
Okay. All right. So those provisions justify why somebody on leave of absence without pay should not be promoted.
Yes, my
or
lord.
should be denied promotion.
Yes, my lord.
Okay,
Because the
we'll
rule
read
says
it.
that you have to be eligible for promotion, and it stated the
Yes.
criteria for you to be eligible.
Yes.
It stated the criteria.
So which of the eligibility did he miss? At least you should be able to point out one.
Okay, sorry, my lord. Just a minute, my lord. We summarized everything in paragraph 4.28, which is what we summarize.
You have produced the rules here. So just point to one criteria in one of the rules, at least that
okay,
we
sorry, my
can
lord.
just
Okay, let me just
see
point
and
out.
pass.
Okay, sorry, my lord. Just a minute, my lord. Okay, let me start from paragraph 4.26, my lord, where we have rule 020701.
Yes.
I will start with the first one, which is paragraph B. That is, all officers who falls within the field of selection for any promotion exercise shall be considered, except those who are under disciplinary actions. The minimum number of years that an officer must spend in a post before being considered eligible for promotion shall be, for that of the claimant, which
Yes,
is
I've
minimum of
seen
4
that.
years.
I've seen that.
Then you
I've
now
seen
go to
that.
C, that promotion shall be made strictly on the basis of competitive merit from among eligible candidates. Then
Yes.
I now talked about that eligibility. In assessing the merit of officer, a clear distinction shall be made between their record of performance or efficiency in lower grade and their potential for promotion. It goes further. In all cases, there is 3 now. In all, however, general satisfactory record of conduct shall also be considered. Then we go to rule 020702, which is on page 16.
Yes.
Before each promotion exercise, the appropriate office shall compile a list of all eligible candidates to be considered. The list should be prepared on the basis of the job requirement or set criteria established by the scheme. Sorry, my lord. Sorry, page 17, rule 050201, page 17.
Yes.
Progress reports are meant to provide, in respect of officers, object on probation or initial court, a full record of each officer's work, conduct, and capability on which to judge its suitability for confirmation or re-engagement, and to ensure that in all cases an officer's ability for continued employment is in doubt, he is given timely warning of his fault. The next rule goes further to talk about annual performance evaluation. Annual performance evaluation. A claimant who has not provided any services within the last 8 years to the ministry, how will his performance be evaluated? He never filled any evaluation form. During this period, he was on leave of absence. He was not reporting to any superior officer, upon which it is competent for the next post could be assessed. So you must pass all these requirements before you can say you are eligible for promotion. And just to go further, my lord, the Exhibit G, with the claimant have attached to it further affidavit. My lord, that ought to be a public document. But the said document is not certified to show that that is from the ministry or from the government. The law is very clear on that. When you tender a public document, it ought to be certified. There is no such certification in this instance. There is nothing to show that it's coming from the Osun State government or any of the defendants, my lord. I will most humbly urge your lordship to reject that in evidence. My lord, just briefly, before winding up my adumbration, the claimant had in paragraph 2.0 to 2.1 of his reply on point of law argued that I did not attach any authority, a fiat, from the Attorney General of Osun State that is in essence challenging my representation of the defendant.
Okay.
My lord, my simple response to that this is not a criminal trial. It is only a criminal trial that the fiat of the Attorney General is required. That is why even the claimant could not even cite any authority to that effect. That in civil cases, a person representing, a legal practitioner representing a government agency must attach a fiat. There is no such law, my lord. And in that regard, may I most humbly and respectfully, my lord, provide an authority in this regard.
Okay.
That is the case of PDP versus Eze Onwuka.
In civil matters, a non-government lawyer does not need
to produce a fiat
of
the Attorney General
AG to represent the government.
Yes, my lord.
See,
my lord, going further, before even going further, the
no,
law
let's
is right.
finish with one sense. See,
yes, so that the case will back it up together, my lord. That's why. So sorry, my lord. Before citing the case, my lord, so that the case can back the argument up.
Yes, continue.
Yes, my lord. In civil cases, the only person that can challenge the representation of a counsel is the client itself, not the opposing lawyer. That is whether the legal practitioner has the right to represent a client. It is that client that can challenge that representation and not the opposing lawyer. My lord, to support this contention, my lord.
Yes.
I most humbly rely on the case of PDP. The case of PDP versus Eze Onwuka. Onwuka, my lord, is ONWUKA. Onwuka, my lord, it's reported.
Citation.
2018. Yes. 2018. 3 Nigerian Weekly Law Report. 2018, 3 Nigerian Weekly Law Report. Part 1606. Part 1606, that is 1606.
Yes.
187 at page 255.
There, the court said.
Where the court said, the rule here is that Honorable David Iyomba, having announced appearance on behalf of the first to fourth appellant, the authority to challenge his representation lies with the client alone. It is now tried that none other than the client, not even the court, inquires into a counsel's authority once he has announced appearance for the party.
Okay.
That's a Supreme Court decision, my lord. My lord, we also urge your lordship.
What was the argument of the other counsel in that case? What was the basis of the challenge to the appearance of the counsel in that case?
The basis of the appearance to counsel?
What was the basis of the challenge to the appearance of counsel by the other counsel?
By the other counsel, my lord. Just a minute, my lord, so that I don't mislead the court.
The appearance of counsel was challenged, isn't it?
Yes, my lord.
On what ground?
That's what I want to check, my lord. Just a minute, my lord. Let me just open up the case. I'm so sorry, my lord. I didn't read the full authority, but that was the holding that
because
I relied on.
You are applying it here to I'm trying to see how it is applicable. Yes, that only the litigant can challenge, yes. But we are talking about government. About government, we know that the government is usually represented by the office of the Attorney General. And
Yes, my
then
lord.
you are not a lawyer in the office of the Attorney General. You
Yes,
are
my lord.
representing the government. And the man is
Yes,
saying, where is the fiat of the Attorney General? So
That's
this
the first part of my
authority
submission, my lord.
does not seem to me like talking about it does not address issue of fiat to represent government. This authority
Okay, my
does
lord.
not address fiat to represent government.
Okay, I get your lordship. But now the
Yeah.
duty lies. He was the one that raised it. The duty lies on him to provide the authority that says I cannot. Because the law is that it is in criminal matters that you bring a fiat. Fiat applies to criminal matters, basically.
You
It is
have not even told me the law.
Sorry, my lord.
Which law is it that says only in criminal matters will you require fiat? You don't tell me. You people will just argue your own from there and then expect me to deliver judgment. And when I deliver judgment, you say it's unreasonable in view of the facts before the court. It's unreasonable and contrary to the facts before the court. Meanwhile, you people are not saying anything. You just make argument, bare argument. Tell
I
me the
apologize for that.
authority for saying it is only in criminal matters that a fiat of the AG is required. Then if I go contrary to that, you can say I refuse to follow the authority cited before me or the evidence before me, isn't it?
Yes, my lord. I get your lordship
Yes.
point. But the first thing first is that the claimant who has raised this objection had the duty to prove first, which he has failed to do. He has failed to
I
do that.
agree.
The burden is on him.
I agree.
To show that you need a fiat.
The first burden is on him.
It's on him. And until he passes that burden, it doesn't shift to me. He has not provided any authority, any law whatsoever that says I cannot.
So here we are, where both of you are arguing without authority, right?
No, my lord. If your lordship permit, after now, I can send additional list of authorities. I can file additional list of authority after now to support my contention, my lord. If your lordship permit, within today, tomorrow, my lord, on this issue.
All right, let's
within
go
today,
on.
tomorrow, I'll file, my lord. I mean, Akure, within today, tomorrow,
Let's
I'll
go
file.
on, please.
Yes, my lord.
Let's go on.
Thank you, my lord. Now, and I heard your lordship to take cognizance of the fact that the deponent to this affidavit is not somebody in my law firm. It is a director.
Deponent to which?
The counter affidavit.
Okay.
It's a director.
Yes.
In the Osun State government.
Yes.
That is office has not been challenged by the claimant.
What is the problem about the deponent?
No, I'm just saying that to further show if there was no authority, why will a director depose to an affidavit?
Okay. I get your argument.
That is the point, my lord. My lord.
That would not stop a legal argument. He is not challenging you. He is not challenging you factually. He's challenging you legally. He's saying, where is your fiat? I'm sure he did not in any way say that the ministry never briefed you. I doubt if that's what he has said. All he has said is that you don't have fiat. So even though the ministry briefed you, he is challenging them briefing you.
And that's why I said he cannot do that, my lord. He cannot challenge them briefing me.
Okay.
That is my own argument. He doesn't have that locus to challenge the ministry briefing me.
All right.
Yes, my lord.
Okay. All right. Thank you.
I'm most grateful, my lord. That will be all. I most humbly urge your lordship
to
to
dismiss we urge the court to dismiss the case.
Yes, my lord. I'm most obliged.
All right, thank you.
Yes, my lord.
Yes.
My lord, by very, very short reaction, sir. Unfortunately,
I don't know on what basis is your reaction, because you already adopted further affidavit. I gave you time to adumbrate. You didn't talk about it.
Yes, my lord.
Yeah?
That's why I asked earlier whether I should react to his processes and wait,
course,
or
I
I
will allow
wait
you
his
now.
submission, my
Did I
lord.
not allow you? Did I not allow you to do so?
My lord, but he has raised other issues now. He has made some
He has
reactions.
only adumbrated and emphasized on his process, which you have responded to and adopted. But all the same, let me hear you.
As a places, I'm grateful, my lord. My lord, to start with, issue of promotion of a civil servant is not a matter of privilege, my lord.
I'm sorry, my lord. Sorry for cutting in, my lord.
It is a matter of law.
Promotion, issue of promotion was raised in my counter affidavit. He filed a reply on point of law just yesterday. He never raised that. He had no right to raise it here.
Please, let's just hear him for purpose of smoothness of the proceedings. Everything is already recorded.
As a places. My lord, we also, if my lord look at all the arguments he has canvassed and what he has raised in those paragraphs, they all deal with procedure in coming up with list of eligible candidates for interview. And we are saying, sir, that the claimant has been found to be eligible. The upper form is talking about everything he has listed. They were pre-interview procedure.
Yes,
so
and the civil service rules. And the civil service, wait first, counsel. And the civil service rule says that once you are eligible, nothing can stop you from getting promoted.
No, my lord. It doesn't say that, but it says once you are eligible, you attend interview.
Good.
So is the outcome of this? Are they being they allow you to attend the interview and they now say, oh, you failed, you did not meet the so. It's a different ballgame, my lord. But he has not been accorded fair hearing. He has not been interviewed at all. He was called to come for interview, which ordinarily is even their duty to set up an interview center close to where the officer is observing his leave of absence without pay.
The question is,
but instead of doing that, they called him to come. That's why being there physically. My lord?
Yes.
Hello,
and you are saying that having shortlisted him for interview,
they cannot renege at that stage, my lord. They are estopped. The estoppel will operate against them. That's what we are saying. And my lord, he also mentioned that we attach a document that is not certified. My lord, this is a proceeding fought on affidavit evidence.
Yes.
And in a situation like this, a document attached to affidavit cannot be objected to, my lord. It cannot raise objection to a document attached to an affidavit. We rely on the case of Gusau against Lawal. Gusau against Lawal, 2023.
Just a moment.
Yes, my lord.
A document attached to an affidavit. Right?
That a document attached to an affidavit.
Yes.
Objection to it, my lord.
In a case fought on affidavit.
Fought on affidavit evidence.
Yes. Cannot be challenged. Right.
He cannot object to it, my lord, as the document of the affidavit.
All right.
And my lord, he
no, you tell me authority. You can't make that assertion.
That's what I'm saying, my lord. We are relying on the case of we are relying on the case of Guzo against Lawal. Guzo against Lawal.
Yes.
The time reported in 2023.
Yes.
Law Pavilion Electronic Law Reports.
Yes. Sure.
60152.
For me, light.
152. 60152. Yes, my lord.
Supreme Court.
It's a Supreme Court decision, my lord.
Yes, it says.
If I may read, it says when a matter is fought on affidavit evidence, or where a document is attached to an affidavit in a matter, any document attached thereto forms part of that affidavit and is thereby already in exhibits before the court.
Already in evidence before the court, or already in exhibit?
Before the court.
Already an exhibit. I didn't hear you well.
I'm reading the decision of the Supreme Court. It says,
well.
any document attached thereto forms part of the affidavit and is already in evidence before the court. The court now went further, that it should be borne in mind that an exhibited copy of a document attached to an affidavit must necessarily be a photocopy or secondary copy, except where the document was executed in several parts or counterparts, that the deponent has many of the parts of exhibits in original forms. So, my lord, another argument against this, my lord, is that,
my lord, before cutting in, my lord, there are other part of that decision that learned counsel have not read. Very material.
I'm going to read it. I must read it, sir. I'm going to read that authority.
Thank you. Because there are other parts there, not below that statement.
And again, my lord, in a situation where a document, it strikes position of the law, my lord. I don't have an authority handy for it now, but I will supply it later. In a situation where a document that a party wants to use in litigation is in the hands of an adverse party, a party who will not ordinarily release such a copy, the party can make use, the law permits the party to make use of the document or of a copy available to such a party. So in this circumstance, my lord, the original document is talking about is with the defendants. These are the defendants that we wrote 5 letters to them. They did not react to any.
Look at that document.
Yes, my lord.
I'm not arguing against your argument, okay? But look at the document itself, that list.
Yes, my lord.
On top is stated Osun State Ministry of Justice, Oshogbo, isn't it?
Yes, my lord. Yes, my lord.
Who prepared the document in the Ministry of Justice? Who prepared the document?
It is prepared by under the watch of the second defendant, my lord. The second defendant will pretend.
On the face of the document, who prepared that document?
The Ministry of Justice. Ministry of Justice.
Okay, the Ministry of Justice produced it, not a person.
Not a person.
God please.
Who is the author of the document?
My Lord, this is a list prepared by the ministry. It doesn't have an author.
The author? Okay, it doesn't have an
The author,
author.
the author is still the Ministry of Justice, presumably, and that's the second defendant, my Lord. We believe the second defendant prepares the list.
Okay. That's
because it's his list. It's a list under his ministry. It's a list under his watch, my Lord. And they cannot rebate from that at least, and they have not in any way or in any fact denied that he was listed as eligible for interview for promotion on that of that category, my Lord. It has never been contested anywhere.
It has, my Lord.
If you filed the process first,
yes,
and
my
you
Lord,
said he was listed, you did not produce this document. Now, if they didn't even deny the fact that he was listed, so what gave the need for you to produce this document on an issue that they are not denying?
No, as a complainant, my Lord, is to convince the court further.
No, you can't convince me with an unauthored document, sir. Because this document, as it is like this, even my secretary in my office can sit down and produce it.
The court pleases.
My Lord, until that is proved, my Lord, sir. Because as it is,
it's on the face of it. In fact, even me, I can produce this document from my system.
My Lord,
because your document has no author, and then it was not certified by the Ministry of Justice. We can agree with your argument on the issue of certification, but on authorship, genuineness of the document.
My Lord, the genuineness, my Lord, genuineness, with all the respect, is clear, my Lord. Okay, because this is the list used for the interview.
What makes it clear is because there is the name Osun State Ministry of Justice, Oshogbo, isn't it?
Yes, my Lord. Yes, my Lord. Okay. And an invitation was extended to him, I
thought maybe it's the invitation that you should display.
No, my Lord, this is a list attached to the invitation.
Okay.
My Lord, no
who should have been in your original? Who should have been in your original affidavit?
As a corporate, my Lord, and what we are now saying now, sir, is
display the invitation? Did you display the invitation?
No, we didn't display the invitation, my Lord, and they've not disputed it. It has not been disputed.
We are just arguing about a non-issue here. If you said they invited him for interview and they did not say no, we did not invite him for interview, then why all this issue? What are we arguing about?
As a corporate, I leave that. I leave that.
Making arguments that will make a judgment bulky, determining no life issue.
I'm sorry, my Lord.
Isn't it?
I leave that area for the secretary of the court, my Lord.
All right, thank you.
Lord,
he also mentioned, my Lord, he also talked about his power, that it does not need to have the fiat or consent of the Attorney General or the Ministry of Justice before it can represent a government agency. My Lord, that power.
Sorry, my Lord. My Lord. Sorry for cutting him, my Lord. My argument is not that I don't need to have. It's that I don't need to exhibit it to my process. That is my argument. I don't need to exhibit it to my process.
We are challenging that. We are saying you do not have the authority to represent the government agencies. If you have, you ought to have at least attach it to your processes. And there is nowhere in his entire processes that he mentioned that he was briefed or he has a consent of anybody to do this with us. So he has not even placed anything before the court.
That's okay. You people are overstressing the argument as if it is an argument that is arising in court for the first time in the legal history of Nigeria adjudication. These are arguments that have always been around, all around.
As a corporate.
So we don't need to kill ourselves making the arguments. We don't have to kill ourselves on the arguments. These are things that have always arisen all through. You understand?
Yes, my Lord.
So,
my Lord, that's one of the reasons we argue is a trite position of the law. Meanwhile, we have a decision of the Supreme Court, which says that issue of fiat is a matter of delegation, and such delegation by Attorney General either that of the Federation of the States, is important in either to prosecute a case or in defending government agency. My Lord, we have the case of EBE versus COP, EBE versus COP, reported in 2008 for NWLR, part.
You see, one thing I always have problem. That's why when I say you people are over arguing, now you are arguing this is a civil matter, and you are citing as authority a criminal matter. Abba, cancel. How can you cite a criminal matter for me as an authority in a civil matter?
Yes, my Lord, because
we're not
it
talking
talks about
just a mere principle of law, but we are talking about representation of the government in a civil suit. And then you are citing a criminal matter.
Yes, my Lord, because the court went into issue of delegation or in whole in all cases, my Lord.
To allay your fears. To allay your fears, the authorities, you must be sure that the court is going to do its own search. When I do the search on criminal matters, they will all be there. I do the search on civil matters, they will all be there. Is it not fiat of Attorney General for a non-government lawyer to prosecute a case? So rest your mind. Rest your mind. The authorities are there waiting for us in Law Pavilion and Nigeria Weekly Law Reports.
I'm grateful, my Lord. I'm grateful, my Lord. Right. And at this juncture, my Lord, I urge the court to discountenance all the arguments and the issues canvassed by the counsel.
I have always told you people, I can never discountenance a legal argument legally made before me in the course of proceedings. I have to rule on the merit of it.
As the court places. So we urge the court to grant our release.
The thing succeeds or it does not succeed, but I have to look at the merit of the argument. Cannot discountenance it.
As the court pleases. I'm grateful, my Lord.
Actually, you're 18th next month. Case adjourned for judgment on a date to be communicated to parties.
As the court places. We are grateful, my Lord.
We are most grateful to the court.
Thank you.
Thank you, Lordship, for the indulgence.
Now, this is number 3. Okay. AK 09-2026 between Akin Shipe, Tomitope Victor, and Ondo State Security Network Agency under the code name, operating under the code name Amotekun Corps. Yes.
May my noble Lord be pleased. My Lord, A.E. Adegoroye Esquire.
A.E.
Adegoroye.
Adegoroye,
my Lord.
You are for?
My Lord, I'm for the J-Mans, my Lord.
You are appearing with someone?
Yes, my Lord, I appear with O.D. Olatunde.
O.D. Olatunde.
And IE Oshoyi Komi. IE Oshoyi Komi, my lord.
Oshoyi Komi.
Yes, my lord.
Komi.
Most grateful, my lord.
All right. Yes, Defense Counsel.
With greater respect to my noble lord.
Yes.
Adekola Olawoye.
Adekola
Woye, SAN, my lord.
Olawole.
Olawoye, my lord.
Okay. Olawoye. SAN. Who is
appearing with me, my lord, for all the defendants.
Yes.
Are my noble colleagues, A.A. Adishola Esquire.
AA or EA?
A.A.
Okay.
Shola Esquire.
AA Adeshola.
Adishola, A.J.I. Adishola, A.J.I.
Adeshola.
Yes, Lord.
And
we have Felicia Carton Esquire.
who?
Felicia, my lord.
Elisha.
Felicia.
Oh, Felicia.
From that part of the state, my lord.
Felicia. As in Felicia.
Thank you. Cartoon is A-A-N-G.
Cartoon?
Cartoon, yes, my lord.
Spelling?
K-A-T-U-N-G. Complete to my lord.
A-A.
K-A-T-U-N-G. Cartoon.
That's
Felicia Cartoon.
Yes, my lord.
You know, why part of why I'm wondering if that's the spelling is. We are here in Ondo State, and I'm hearing a Kaduna name.
Thank you very much, my lord.
Okay.
O Ajayi Esquire. A-J-A-Y-R.
O Ajayi.
Yes, sir. We
All
have
right.
Our appearance for all the defendants in this system. We are obliged, sir.
Okay. All right. Ajishala. Okay. Adekola Olawoye. Lanesuk.
My lord.
It's like you are new in this my court. I don't remember this name.
Thank you very much. That was why I first of all greeted my lord.
Yes, and that's why you and your colleagues,
I think
them Felicia Cartoon, all
about
the names are sounding very strange to me in this jurisdiction.
Thank you,
That's
my lord.
okay. All right.
Well, most of the lawyers that appeared from with
Adegoroye.
My lord.
Yes.
We have before the court this morning a motion to consolidate this matter and some sister matters, my lord.
We have a motion on notice for consolidation. The motion is dated.
My lord, the motion is dated 16th day of March, my lord.
Which day?
Dated 16th, my lord.
16th March.
2026, my lord, and filed on the 17th of March, 2026.
Where did you file it? 17th March seems to be yesterday.
Yes, my lord, we filed yesterday.
Which registry did you file it?
At the registry here in Akure, my lord.
Me, I wonder why a matter will be coming up today, then you file motion to yesterday. The motion is not in this file.
My lord, you are sorry, my lord. I would have to take
You want to
responsibility for
consolidate
that, my
which
lord,
suit
due
with which suit?
to my own health condition and the
You
structure of
want to
the
consolidate
chambers, my
which
lord. I'm
suit
sorry.
with which suit?
My lord, this matter has two other sister cases filed by
All
two
filed
different,
before this court.
all filed before this court. Yes, my lord.
Okay. There is one AK 07-2026 by Jimmy Julius.
Yes, my lord.
It's the same complaint.
The same complaint, the same defendant,
the same
facts,
facts.
my lord, the same issues. Yes, my lord.
And then the third one.
The third one is AK 08-2026, my lord.
Okay. Okay, so you want to consolidate 07,
yes.
08, and 09.
Yes,
isn't
my lord.
it? As one suit.
Yes, my lord. As
okay.
one suit, my lord.
And it's a complaint.
Yes, my lord, it's a complaint. They are all
okay.
complaints, my lord.
The problem now is that even the motion you made mention of is not in the file.
I'm sorry for that, my
have
lord.
you been served with the motion?
My lord, very well. We were served at about 6 p.m. yesterday. And as far as we are concerned, my lord, for the speedy trial and disposition of the three cases listed on the face of the motion paper.
Okay.
We are not objecting on consolidation. We are not opposing. We are not. We are even happy that such an application is brought by the claimant.
Okay. Okay.
The same issue, the same party, and the same witness.
Okay. Okay. The motion was not put in this file that I just called. Okay.
Yes, my lord.
I called 09 and the motion was not put in the file in that 09.
Yes, my lord. We are sorry for that.
Okay. It's all right. So, since he's not objecting, Adegoroye.
Yes, my lord. May I move in terms of the motion paper?
Acting for the four defendants, we are not objecting or opposing consolidation of the three sister cases together as one in this court before your lordship for proper and speedy adjudication. That's our position.
You appreciate the learned Sikh for his gracious position. Thank you, sir.
You're welcome.
Application granted as prey. Suit numbers NICN/O/AK/07, NICN/AK/08, and also 09/2026 are hereby consolidated.
As the court pleases. Most grateful, man.
What next? Adegoroye, what? Yes.
Is that we filed a preliminary objection, notice of preliminary objection. So the competence of the three.
Adegoroye. No, Adegoroye is for the claimant.
Okay.
Adekola is the.
Sorry, Lanesuk, I asked Adegoroye to talk and you started talking.
I'm sorry, my lord. I kept quiet because I noticed that the learned Suk was already
yes,
on
but I called your name, so I had written your name on paper already
sorry,
as the one talking, and I heard the sweet voice.
so sorry, my lord.
So what next, Adegoroye?
Yes, my lord. I believe that the learned Suk is about to introduce the preliminary
You talk
objection
first because your name is on record. Just
as the court places. My lord, the defendants have filed a notice of preliminary objection before the court, my lord, against the suit.
You have not said whether you are ready for hearing, you want a date for hearing, you are not talking about your case. Talk on your own side. Is this a selfish one first?
As the court pleases. My lord,
use the principle of selfishness here.
My lord,
speak for yourself only now.
As the court pleases. My lord, we would like to respond and file a reply to the defendant's statement of defense, my lord.
You need to reply to the statement of defense. Yes, so what do you want?
My lord, we'll be praying the court for a short date to file our reply to this matter.
Okay. Learned Silk.
My lord.
Yes, it's your turn now.
If I can hear
we filed a notice of preliminary objection on.
We filed it on the 25th day of February 2022.
Yes.
In opposition to the competency or otherwise of the three already consolidated suits before your lordship. And yesterday, we received a counter affidavit against that preliminary objection. We got it at about 4:30 yesterday. And we want to react as provided.
Okay. Yes.
Because if our preliminary objection fails to, that's the end of this case.
Your complaint is that the court does not have jurisdiction because the claimants failed to exhaust the mandatory administrative remedy provided for
over the law that established
under section 24, 28, 29 of the Ondo State Security Network Agency and Amotekun Corps Law 2020. You want me to strike out this suit also because it constitutes an abuse of court process by reason of the pendency of another suit with suit number HCAK 478 C, is it CIV or CLV 2025? A fundamental rights action arising from the same facts and subject matter pending before the Ondo State High Court of Justice, Akure. Okay. Okay. You have responded, you have filed a counter affidavit to the, he filed a counter affidavit to the PO.
Yes, my lord, we have.
And you want to file a reply to, is it a reply or a further affidavit?
We want to file a further affidavit and along with a written reply on points of law as provided by the rules of this honorable court, that is to say, Order 17, Rules 11 of the rules of your lordship gives us that privilege, and we want to exercise it.
Date. All right, so we take a date.
But I wouldn't want us to take a date and we come back to this court again, because we file and serve our PO since 25th day of February 2020.
You don't want us to take a date and come back to the court again?
And come back to the court.
So what do you want us to do?
What I'm saying now is that if my land, because we have not been served with any motion for extension of time within which to file this counter affidavit that was served on us yesterday. They have been served.
So what do you want us to do now?
No, I don't want us to come on the date that will be given to us, and I'm arguing this way. I'm sending a note of warning that this counter affidavit is not properly before your lordship.
Okay, you are pre-informing him.
That's what I'm doing.
My lord,
he has just pre-informed you, so you hold your argument until when it becomes an argument before the court.
As the court pleases.
Yes, but he has pre-informed you. Make use of what you can use it for.
My lord, we appreciate.
Then when it arises before the court as an argument, yes, then you can now respond. Yes.
As the court pleases.
6th of May. Okay, case adjourned to 6th May 2026 for hearing.
My lord, sir.
Yes.
Pardon, my lord. 6th of May. I feel I have a 6th of May. This is May. Where is the covenant, my lord?
It's a Wednesday, sir.
The Wednesday, my lord. This covenant.
Thank you very much.
Pray for me, your lordship.
Say 18. All right.
It will be the end of the day. That of the consolidated the two. So
Okay, we have consolidated, so no need to call the second matter again because they were all listed.
Thank you very much.
So that shall be the end of the Zoom meeting for today, and we may all leave. Okay, the adjournment, we are coming to court physically, okay. Sorry. You will come to court physically.
The 6th of May.
Yes, 6th of May, you will come to court physically. We took it by Zoom today because court is under renovation and it would not be convenient for me to sit in court today. That's why we decided to take it by Zoom.
My lord.
Yes.
I'm sorry, my lord, my network went off just now.
I said we are coming to court physically, not by Zoom on the 6th of May.
As the court pleases.
6th of May is not on Zoom.
As the
it's physical appearance in court.
As the court pleases.
And come ready to argue your cases.
As the
please.
Court pleases.
At least we should do some business on that day.
As the court pleases. My
Thank
lord,
you,
I have to say it is a pleasure to appear in a matter where the learned Silk is appearing, because the learned Silk might not remember, but he signed my bencher's form when I was about to be called to the bar.
Good.
The learned Silk was the Attorney General.
Okay.
And so I came to and I went to the learned Silk office, and he asked me, why should I sign your bencher's form? I said, because we are going to meet one day, and you'll be proud to say that is my boy.
Yes, and I urge you to make him proud. in knowing your
so,
law and arguing your law well before him.
I appreciate the court, my lord. Thank you.
Thank you very much.
And I appreciate the learnership too. Thank you, sir.
All right, thank you.
Yes,
all right, gentlemen, we can all leave. The animals are leave now. Not seeing.
My lord, I would like to seek the direction of the court that in view of the application consolidating the matters, there will be no need to address the second case, which is also listed on the court list for today.
That is what I said.
As the court places.
I said since we have already consolidated them, no need to mention it. And the next adjourned date, it will all be the 3 matters in one file.
As the court places. Thank you, my lord.
Thank you. Where is the... We can leave, please.
As your lordship places. Thank you very much, sir. Ima